talking about the next one is the settlement conference, right?
Yes. So basically, everything that we said about a case conference applies at a settlement conference. It's the next step.
Yeah.
But what you'll see, and again, there's a form for a settlement conference brief in the rules, but it's the same process. Like once you've gone through your case conference, then either party can bring a motion, or there's a date set for the next appearance, which would be a settlement conference.
Oh, cool.
Okay, then again, you're going to be in front of a judge. It may be the same judge that heard your case conference, or it may be another judge. The one rule is, though, that any judge that sits on a conference with you cannot be your trial judge, because they're hearing offers that you're making back and forth. They're getting all kinds of information and stuff that's not coming in the form of sworn evidence. They're there to try giving the benefit of their experience to the parties to say, you know, really, if you think you're going to go to trial and win on that issue on this evidence, not going to happen. And the judge is free to tell somebody that at a case conference, settlement conference, or whatever.
But can they be a motions judge? Because you said they can be your trial judge, yeah, but so I assume they can't be your motions judge either.
No, generally, once a judge is in, okay, you've got case management judges, and again, depending on the jurisdiction, there are some jurisdictions where you get a case management judge, who is the judge that you appear on your case conference. That will be the same judge you sit with at your settlement conference, and it will be that same judge when you do your trial management conference.
Cool.
There are other jurisdictions, though, where they've got lots of cases and not enough judges, and they trade off. You're not necessarily going to see the same judge at each of the different levels of conference, but any judges that you do see in the conferences will not be hearing your case in a contested matter. So like a judge can't hear a case conference and then do a contested motion, and they certainly can't hear the trial at the end of the day. Okay, so with settlement conferences, again, you go through the same reasons why you have the case conferences. You're exploring the chances of settling the case. You're trying to narrow down the issues that are still in dispute. You're doing the backtrack, seeing, okay, was there disclosure that was supposed to be made before the case conference and it wasn't, and has it been made now? Are there further requests for disclosure? Is there more information that needs to be done? Has there been any movement with expert reports if they are going to be needed? How is that working out? Are there going to have to be any orders made about the expert reports? So again, it's another tool and mechanism to see if you're going to resolve issues. Noting any admissions that may simplify the case. So if parties will agree to like certain facts that you don't have to then produce evidence for if it goes to a hearing, that will help save time and again, what the judge will do is hopefully give you their view as to how a trial judge is likely to decide the issues that are still in dispute. If the case isn't settled, now this is different because now you're moving one step closer to trial.
Right.
In a settlement conference, if the case is not settled completely, then at the settlement conference, that's when you start trying to identify who the witnesses are going to be or other evidence that needs to be presented at trial. So as we said, so you're actually in this conference, you're moving a step closer to the trial.
Right.
So you're thinking more about saying, if you can't get everything resolved and there is going to be a hearing, who are the witnesses going to be? What is the expert evidence that's going to be called? And starting to figure out the next step, which will be, okay, now you're going to be appearing in front of a trial management judge. To really start saying, okay, this is how we set what the rules are going to be for what the trial or the hearing is going to be. Which then takes us to the trial management conference. But again, the process for settlement conferences, the rules are pretty much the same. Like the time frames are the same. That you've got, if you're the one that's asked for the settlement conference, you've got 6 days before the conference, you've got to serve and file your brief on the other side. The responding party has to do it 4 days before it. Then the parties have to file confirmation. So always the conference process is the same for every one of these steps. You've already done your documentation for your lawsuit, so now you're doing the things for what is specific to the conference system, which is doing the brief, serving it, uploading it, getting it in the court file, and then hauling it out again before you do your next hearing or your next conference. So the final conference is the trial management conference. So this is when things are getting really serious, because it's when people are saying we cannot reach a final resolution on these issues. These are the things that are going to be going to trial. So usually the trial management conference is held a month or so before trial actually starts. You will have some jurisdictions where they might combine part of a settlement conference with a trial management conference. So, and again, depending on the jurisdiction, your trial management conference, if it's not combined with the settlement conference, could be heard by the judge that's actually scheduled to hear the matter at trial, to just deal with like the mechanics for what needs to be done for the trial. So what the whole point of the trial management conference is to try to organize things so the trial, when it happens, will be run as efficiently as possible with as few surprises as possible. So again, primary purpose is to see if there's any chance of settling the case, one last final shot at it. Arranging to see if evidence can be received by a written report, an agreed statement of facts, an affidavit, or whether you have to call a live witness. Deciding how the trial will proceed. Will it be virtual? Will it be in person? Are we doing it just by exchange of affidavits, or are we actually going to be calling live witnesses?
Right.
Talking about the expert evidence or reports that are going to be expected to be used at trial, including the time requirements for serving and filing expert reports. All that stuff under the Evidence Act, which can get really scary no matter what kind of court you're in. So you have to start getting, if you're going to be going to court, by this time you should know who you intend to be calling as witnesses. And you have to provide the other side with your witness list. And you also have to provide an estimate of how much time you think it's going to take that witness to give their evidence at the trial. So you get all these components coming in. So at the trial management conference, you're actually figuring out how long is this trial going to be. Is it a half-day trial? Is it going to be a full-day trial? Is it going to be a week-long trial? Is it going to be a 3-week-long trial? So that's where you start sorting all that out, because it'll be where it's worked out at a trial management conference that will help the trial coordinator schedule the time for when the trial is going to be heard, because then they'll know how much time they're going to need to do it.
Right.
So then ultimately what the outcome of a trial management conference would be to set a date for the trial, if it's not already been set. Okay, so normally once you've gone through all these on a trial management conference, there is a form. Again, we love our forms. It's a trial scheduling endorsement form. Okay, so some people get those confused with like the trial management conference brief, but they kind of go hand in hand. So both parties and the judge have got segments that they have to complete in trial scheduling endorsement form, because it'll go through and confirm what they're saying, who the witnesses are going to be, how much time they're going to take, what are the expert reports that are going to go in, how are those going to be presented, are there any agreed statement of facts, and you do it all. So the parties are usually directed at a settlement conference to get this form completed by a specific date, and that it has to get filed with their trial management conference brief. So it's all just there to make sure that you're getting as tight of a timeline as possible for organizing your trial. So as with the case conference, a judge at a settlement conference or a trial management conference can make disclosure orders and various orders as discussed above. Briefs are always required for any type of conference. The time service requirements are the same for all conferences. And again, you have to be present. You can't just send your lawyer to act on your behalf when you're attending a conference at any of the three, be it a case conference, settlement conference, or trial management conference. Okay, now the one thing, because remember I'd said before, is the briefs for case conference and settlement conference go into the court file, so the judge who's going to be at the conference with you has a chance to see what both parties' positions are from reading the briefs. A trial management conference brief is part of the continuing record, because it's the one that's got the information about saying, okay, this is how we are structuring our trial, this is how we're getting ready. So other than after the trial management conference, the briefs from case conferences and settlement conferences are returned to the parties. They actually do require, especially the settlement conference, it specifically says attached here to is my offer to settle on the following issues. So literally they are trying to get people to settle at every chance they possibly can. The closer you're getting to the trial, the more pressure there is being put on you to say, if it is reasonable, you should really consider trying to reach a settlement. And you have to give the particulars of what your offers to settle are. But again, that's why the trial judge can't see those things when they're there. So no statement made at a settlement conference can be disclosed to any other judge unless it's part of a court order or if the parties agree to it during the settlement conference. And again, as with case conferences, you need that confirmation form 17F for settlement conferences and trial management conferences. So that's conferences. They're actually not that complicated. It's a little weird because you're in front of a judge, but you're not arguing your position. You're not presenting evidence. It's a chance to talk with a judge in a more relaxed, informal circumstance. Nothing is done under oath. There's no evidence being presented. Everybody is there just to talk to each other.
Oh,
If this
wow.
is where you're going to lose it and call the other side, excuse the language, a bitch or an asshole, don't recommend doing that. But it happens at conferences because people explode, but it's a chance to vent. You should still be polite and follow the rules of courtesy and etiquette whenever possible. But they want the conferences to happen in a place where the people are all comfortable saying exactly what they think and getting their position before a judge. Sometimes when a person is asking for something on an application or in their answer,
Mhm.
they might be saying one thing, like the documents will say, this is what I want. And then when you get to the conference, it turns out, maybe that's not really what they want, but they just did it because they knew it would drive the other side absolutely crazy. And it's not really what they want after all. So again, this is a chance for people to be honest and open and to sit down and meet with the judge and get the benefit of the judge's experience.
Oh, I have a question. So going back to the settlement conference, is this something that the court will set the date for, or do the parties have to ask for the settlement conference? Like who is it who actually calls?
Okay, once you've done your case conference.
Yeah, the case.
Yep, so you've done your case conference. At the case conference, okay, your matter just can't generally go in. Well, it happens sometimes, but it's not supposed to. It's called adjourning to the timelines.
Yeah.
It just basically means that once you start a court proceeding in family court,
right,
the timelines mean that within 365 days, that matter has to be 100% resolved, one way or the other, either by hearing or by settlement.
right.
It's more honored in the breach than in what happens. But what it means, if you adjourn something to the timelines, it just means that you're not setting a specific date for another court appearance to happen. You're just adjourning it indefinitely. Either party can bring it back later on, as long as you're keeping in mind that you've got to get your whole thing done before you reach the end of the timeline that starts once you issue an application. Okay. But so what happens normally at the case conference, the court will more often than not set a date with the parties and their lawyers present
Okay.
for what the next court appearance is going to be.
Got it. Okay.
It may be a settlement conference. That it might be saying, okay, we are going to set a date for settlement conference 4 months from now, knowing that somebody is going to be bringing a motion in the meantime. So then the argued motion will be heard in the meantime whenever the parties, but it's scheduled for, and they can argue it. But they know when they're coming back on their settlement conference. If there isn't going to be a temporary motion in between, then at the case conference, you would set the date for the settlement conference. The settlement conference, you would set the date for your trial management conference. The judge will be there. The judge has access to the trial coordinator's office. So that's like when they're scheduling it, you're making sure with the trial coordinator that you got the time. You're looking for who your judge is going to be. Is it going to be the same judge that you've done on your case conference that will be hearing your settlement conference, or does it have to be somebody else? But they've got right at the conference, they've got contact with the trial coordinator's office for the purposes of ensuring a date. So yeah, the date is normally set at one hearing for what the next appearance is going to be, but that's negotiable. Parties can talk to the judge about it and decide what date works the best for everybody, check to make sure the date's available with the trial coordinator, but the date will get fixed before you leave your conference.
Oh, that's so much nicer than civil. It's different. Yeah, it's different. I think that maybe on the civil side, there's a lot more that the parties have to do. But here I can see it that there's a lot more support from the court for the parties. Okay.